This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Port St. Lucie County, Treasure Coast, and very much beyond. We have somebody listening from Montreal, Quebec, Canada. And we will interrupt my ordinary introduction and go straight to John from West Palm Beach. Hi, John. How are you?
Well, thank you. I appreciate that. I'm fine. How are you today?
I'm doing all right. How can I help you?
Well, I think you said you had some background also with condominium questions. Can I ask you one of those?
Yes, a little bit in regard to HOAs and things like that, yes.
Yes. Well, this is the problem is we've had a property manager for a number of years now, and the property manager is supposed to be working for us on our clock, on our dime, but unfortunately over the years, since they've been here so long, that they've decided to have businesses on the side as they're actually on our clock. So what I'm asking is, we have in our docs that we can't rent property more than once a year. You can either do 6 months or 12 months.
Right.
If you leave early, you're out of luck. So the problem is, it's been discovered recently that units were being rented for less than 6 months and more than twice, sometimes 3 times a year. And my question is, the Department of Business and Professional Regulation has a compliance office, but they're not going to help you with this thing. In fact, they've really, over the last 30, 40 years I've lived here, their powers have been shrunk down to real basic
And
things.
so has their staff.
Yes. So, how could a lawsuit against a property manager progress if you really don't have access to these records?
All right, first of all, under the statute, the Florida statute that provides you with access to specified records, it delineates the types of records that any owner, a condominium, homeowner, mobile home park owner, they're all separate chapters in the Florida statute, but they all give you rights upon reasonable notice, usually 24 or 48 hours, to look at a number of records, the minutes, board of directors meetings, financials. Everybody has a right who is an owner to have access to those materials. So, you make a written request. Probably you can Google the statute and find the actual statute number. And you just make a request pursuant to the statute. Then if they don't comply, they run a lot of big risks in terms of attorney's fees and fines and penalties. But that's just a part of it. In terms of the property manager not doing what they're supposed to or going beyond what they're supposed to, having businesses on the side if they're supposed to be exclusive, you really have to go look at the contract that the HOA or POA or however you have it structured has with the property manager. Because if it says exclusive, then they're in breach of contract. And if they won't comply, based upon a simple demand letter, then you're right, it's a lawsuit for breach of contract, with damages and, possible injunctive relief. There may be a clause for you to terminate the contract with the property manager early under certain circumstances. And so that's where when, people would call my office, the traditional thing we would say is we need to read the contract. Because until you actually see the terms in the contract, one never knows how well or poorly it's written, how detailed it is or not detailed. The third thing I would say is presumably you have a board of directors. The board of directors should be taking appropriate action, both with respect to the property manager and also if owners are renting their units more often than the bylaws permit, they should be sending them notices, of default or noncompliance, and give them the statutory opportunity to cure. And if they don't, fine them, place a lien on the property, There are a whole number of things that the statute permits, ultimately even foreclosing on the lien. So, a lot of that oftentimes will get people into compliance. So there is a lot that can be done. I would actually, given the nature of what's going on, I would say that you probably need to ask a lawyer, but a little bit more than on a radio show. You probably, whether it's in Palm Beach County or whether it's me or whoever.
Where are you located?
I'm in Stuart.
Okay.
Not that far north.
Not too far yet.
Somebody needs to look at the contract with the property manager. Somebody needs to look at the declaration of covenants, the bylaws, and the rules and regulations. Those are usually the three documents I always tell people in any homeowners, condominium, mobile park dispute that I've got to see. In this case, I would add the contract, with the property manager. And after looking at those things, any lawyer, including myself, can probably give you a much better assessment of what your rights are, what your options are, what is more likely to work at the least expensive cost, rather than just, immediately launching a lawsuit.
Mm-hmm. May I ask one
Sure, absolutely.
quick other
Go
question?
ahead. Yeah.
When we sell properties in here, of course, it has to be approved by the board. Same for the renters. And for some reason, we've allowed people to rent their property below what is normal rates in the area. Can a board refuse a rental that is below what the average rental is in the community? Do they have that authority to say no? Because it says in the docs, the board has to approve, is subject to approval of the board.
I know this is radio, but we're also streaming live on Facebook, and if you could see me, you would see that my teeth are sort of closed and my mouth is parsed because we're running into dangerous areas there. If you start to prescribe the rents that can be charged, I honestly am not certain, but my red flag. Go ahead.
Let me just say that the purpose of the question is because of property values.
Right.
And if you keep allowing rentals to come in here and it's below what the normal average rate is per square foot in the county, and also for selling property, when you sell property way lower, because I know when I bought in here, the property manager, this is many years ago,
right,
said that I can't accept that price, it's too low.
Well,
I mean, that was told to me by the property manager. He said that the board would never approve this sale, so I had to
sounds odd to me.
Change my price.
That honestly sounds really odd to me and sends all sorts of alarm bells off in my head. You may, and I'd have to do research, honestly, and there may be others that know offhand, but
so there's no way for the board to I thought it would be a fiduciary responsibility for any board in a condo or a homeowners association to protect property value.
Well, it is, but the problem is when you start getting into what I will loosely call price fixing, and all sorts of issues as to controlling price. Mm-hmm. Now, maybe you might be able to do it in rentals, and again, there are some people who may do 50% homeowner condo law work, and they may know it off the top of their head. That's what happens when people do more of something. I would have to research it. I have alarm bells, but I could see where maybe with a rental you can get away with it. On refusing a sale because the price is too low, if I was that homeowner, I'd be suing the board immediately.
Yeah, well, I was a younger man back then, and I didn't have the funds, and I just wanted to buy and get in.
You.
The difference was within reach, so Thank God I was able to come up with the difference. But we do have a bylaw, rule and reg that says that owners cannot rent for 6 months. They have to be a resident.
Right, and that's okay. And many municipalities, have ordinances that restrict that, so that they don't have what they call transients.
But how do you know how long someone's in there? How do you know that you? If
the contract and the lease has to be approved by the property manager or the board, it's easy enough to tell. And if you don't give it to them, then you start being fined pursuant to the rules and regulations.
Well, how do you know that those people left and new people are in there?
Everybody knows. This is people know. The
Okay.
next door neighbors know.
Yeah, if you live in a condo,
The
your
Yentas
neighbors
know.
know.
Okay.
The condo commandos know. Believe me, you can't get away with it. If your grass is a quarter of an inch too high, you can't get away with it.
Because these websites have the come rent my place for a week, so how you could have somebody turning
But
over
in
their
places-
apartment.
In places where, for example, you cannot do that in Vero Beach.
Okay.
It's an ordinance.
Yeah. Well, yeah.
Okay.
A lot of the cities are that way, but the
All right.
people are still doing it.
Well, and they could be caught, and they could be.
How do you prove though that there's new people in there every 3 weeks?
Well, first of all, people generally know, neighbors know, and then once you sue them, you have the access to discovery, and you start getting copies of leases or payments that are made, and you see how often and.
But
who
they
the
say
different
they're
people are.
guests. They're visiting.
All right.
Okay.
Yeah, well, we can all fight over
Do you
that.
have-
a little bit.
She's actually, you're bringing up excellent questions, and I respect the attorney too. And but the key word that you just mentioned was sue, and that's where a lot of us won't go that far
Right.
because that's expenses. And,
You're right.
And she's right. She's like,
But sometimes
a
a
lot of
demand
this is
letter will
happening.
work. Sometimes, usually, before I would advise a client to launch right into litigation, I would say, let's try a demand letter. Let's threaten, hell and fury that is going to rain down on you.
Now, as a resident, would you send that letter to the board?
Oh, absolutely.
Okay.
Absolutely. And probably the property
And the
manager.
demand letter would be for the records of the rentals, you're saying?
Well, it would be for whatever I need, but it would also be, we're aware that this is going on. Stop it.
Mm-hmm. Do your job.
Yeah.
Cease and desist.
Yep.
And we want access to certain records pursuant to Florida statute XXX.YYY. Parens 3, some parens little a, little parens 1. And that's really the way it looks. That's really the way it goes.
I've read 718 and the the parentheses and the letter, and you're trying to figure out, well, which letter belongs to what number?
Exactly. Even as a lawyer, when I go to quote a section like that, I've got to scroll all the way up to see, is the little b part of the big 3, or is the 3 part of the large B? It gets rather convoluted.
Well, thank you for your time.
You're very welcome. Take care. And now I think if we still have Michael from Port St. Lucie, I'm like, no, Michael's gone. Michael, sorry we didn't get to you that quickly. If you're listening, please call back. All right, until we do get another call. Today, folks, is National Speech and Debate Day,
Wow.
proclaimed by the United States Congress. You see, I'm wearing a little pin here
Cupcakes
that
today?
says, "We are speech and debate." My team at LPA are wearing their pins and brand new shirts that came in yesterday.
So they look like a team.
They look like a team.
Awesome.
Next week, they may even be doing little presentations of their pieces in other English classes to just show people what speech and debate is all about and what can be done and how good some of them really are.
Yeah, it's a marketing tour, right?
Well, that's part of it. Yes, that's part of it.
Yeah.
But part of what I'm going to do right now is do a little soliloquy until we get a call, because it's National Speech and Debate Day. One of the things I recently just put up on my Facebook page and on, excuse me, Michael's back?
Mm-hmm, yeah.
Okay, Michael, how are you?
Good, how are you?
All right, how can I help you?
Yeah, I just wanted to know what's the maximum amount, percentage they could take for child support?
Ooh, good question. I don't know the answer to that.
Okay.
I don't do enough family law offhand to know the answer. It's definitely in the statutes, and I know there is an official, child support worksheet, but I can't honestly give you an answer to that.
Okay, thank you very much, sir.
I'm sorry I couldn't help that.
Have a great day.
Take care. Bye-bye. Now, that happens.
Mm-hmm.
That's why if I'm in my office and I go to the computer, start Googling,
Yeah.
look at the statutes, sometimes able to get a quick answer, not so much on the radio. So at least, folks, if I don't know the answer, I'm going to tell you, because it does no good to give you the wrong information. All right. Anyway, so wow. Okay. Just somebody in particular watching that sort of surprised me. So because it's National Speech and Debate Day, I want to tell you a little bit about my experience and what I've posted in a little video testimonial on my Facebook site, on the LPA unofficial team site. It all started in a log. No, okay, that's wrong story. I, in high school as a freshman, was a CDF student. Certainly did not think of becoming a lawyer, had no idea what I would do, didn't care. I think I actually thought I was going to be the starting first baseman batting cleanup for the Mets. Yeah, it didn't really happen that way. And my sophomore year of high school, I had an English teacher, Mrs. Collins. I remember her very well. I was a class clown, and I was acting up one day in class, and she put me on the spot in front of the entire class and said, "You think you're so smart, you know what? Why don't you go join the debate team?" And so, not really knowing what that entailed, I said, "Well, okay, I will." Didn't realize it was a lot of work.
Smart teacher, wasn't she?
Smart teacher, wonderful teacher. Yeah. Cannot thank that teacher enough. My goodness, sometimes you really encounter teachers, high school, college, law school, certain teachers that really have massive impacts upon your life. And again, a little deviation here, but my goodness, in our society, teachers are undervalued, underpaid, underappreciated. It's horrific. They are so much more valued in other societies, and you wonder why our educational system has problems. You know, treat the teachers better, and maybe our kids will learn more. But that's a whole nother soliloquy. So I go join the debate team, and nothing magic changes overnight. But as they get me into tournaments and teach me how to research, I start learning a skill. I start learning how to listen, very important skill. At the same time as I'm listening, I'm learning to take notes, another important skill. I'm also learning simultaneously to make notes as to cross-examination questions I'm going to ask when it's my chance. At the same time, in another part of the legal pad, you separate these legal pads, I'm making notes as to my own substantive speech. I already have something prepared, but now I'm modifying it on the fly.
Mm-hmm, yeah.
And at the same time, old-fashioned, that didn't have computers back then, I am pulling out little 3.5 by 5 index cards from 2 file cabinets, file drawers that I brought with me. U.S. News and World Report on February 5th, 1920 says all the research. Trying to pull out the right cards under the right subheadings based upon what this person who's speaking is saying. All that's going on at the same time. I don't know how anybody does that.
But you realized that you could do this.
Eventually you learned that, yes, you can do this.
Not everybody would have been able to join that class and be able to pull that off either.
Well, I didn't know how to do it in the beginning.
That teacher would have been wrong.
Oh, I didn't. No, they're not wrong.
Yeah, but it suited you, Stuart. It suited you.
I had no idea how to do any of that. I had to be taught. And my grades soon began to change a little bit. B's, C's, and D's. The F's disappeared, to my parents' pleasure. And then, the next year, as the team is winning a state championship in New Jersey, and my 4-person team is winning the novice state championship. Boy, what an accomplishment. Mm-hmm. Let me tell you something.
Sure.
What an important day in my life, winning a state championship, I'll tell you. I'm realizing that my grades are now A's, B's, and C's. And by my senior year in high school, they were A's and B's. Shocking my parents when a teacher during a parent-teacher conference said, "Oh, Stuart keeps me on my toes every morning. I have to read the New York Times because he's going to come in and ask me a question about it." And one of my parents, I don't forget which one, said, "You have the wrong student. That's not our kid." "Oh, no, that's your kid." They knew I was debating, but they had no idea. They knew I was bringing home trophies, but it didn't compute. They had
that little
no
club
idea.
thing that you were doing at school? Yeah.
They had no idea what was going on.
It's keeping you busy, and they were happy.
So now all of a sudden, I wanted to go to a good college.
Uh-oh.
I wasn't thinking about that way back when. But, enough D's and C's and...
They never thought they needed to prepare for that.
Right. I was going to be first baseman batting cleanup for the Mets. Making millions of dollars. So I ended up, I got into a good college, and I got a partial debate scholarship. And we were traveling all across the South, every weekend. And then you had to learn, you had to learn during the week, get your work done. Because the weekend you're away debating, okay? You didn't have the weekend to do work and studying. So then I end up transferring back to New Jersey to Rutgers, and I'm now doing actually speech, which I also did in high school in addition to debate. And speech is a whole bunch of different events. I mean, poetry, informative, persuasive, humorous, drama, everything you can imagine they have. And it's a whole different set of skills. Okay, so what happened?
Do you prepare speeches for other people to deliver, or speeches for you to deliver?
You prepare speeches
that's
to deliver.
harder.
You prepare you don't become a speechwriter. You prepare speeches for yourself to deliver.
Okay.
Although, let me tell you, there are plenty of varsity members of the team that would help me and others write things and prepare things and learn things and how to do things. Because I remember one year, my first year at Rutgers, we were in my team, it was a number 3 team in the country in individual events, public
Great.
speaking.
Mm-hmm.
And everybody qualified for the national championships. And there were 2 of us that were new. They all wanted us to qualify too. They wanted the whole team to go.
Sure. Mm-hmm.
And so they tried to help us with the last couple of tournaments find things that we could sneak in and just qualify. Well, I didn't qualify. And it was rough watching an entire team go off to national championships and be left behind. But next year, I qualified in 5 events. So, it takes time. It doesn't happen overnight. But all of that led me to realizing I had certain skills, I had certain capabilities, and without it, I wouldn't be a lawyer today. So, on National Speech and Debate Day, I got to tell anybody who's listening, anybody who has kids, man, get them into speech and debate, really. And if the school doesn't have it, at least in St. Lucie County, Lincoln Park right now is the only one. If your school doesn't have it, you're allowed to participate in a school in the district that does. So come on to LPA, at least for the extracurricular. The value cannot be measured. Everybody is going to negotiate to buy a car. Everybody's going to ask for a raise. Everybody, well, not everybody, but most people are at some point going to have to give a presentation of some sort. There's nerves. There's stage fright. There's a lack of skill as to how to do it, a lack of self-confidence. This is something that carries with everybody for life. And I can't endorse it enough. So then don't forget Mr. Popkin, my mother says. Yes, Mr. Popkin hadn't nothing to do with speech and debate, but that was 5th grade, and just since my mother has mentioned it on Facebook, Mr. Popkin saw something that nobody else saw until then. He saw I had a learning disability. Wow. Called my parents in and said, your kid is not stupid, but I think he may have a learning disability. So he suggested a place for them to take me. And they did, and I was put on all sorts of machines and, reading and, what did I see, memorizing, how many things did I see. And they said that, and I'm not going to get this exactly right, but the gist of it was, one hemisphere of my brain was not communicating with the other hemisphere of my brain. And they needed to train it to communicate. So I don't remember whether it was 6 months or a year, but my parents kept taking me to this place where they put me on these machines, and I then have to, remember what happened and remember the sequence of numbers or colors or animals or what have you. And they literally trained my brain to communicate more effectively with both hemispheres. So if it wasn't for Mr. Popkin in 5th grade, my goodness, telling me to go join the debate team would not have accomplished anything. So, yeah.
Were you too busy in class doing your own thing?
I was a class clown.
Oh, yeah.
I was getting thrown out of class every day. That was what I was. Okay? I was bored. I didn't like it. I didn't think I was any good at, the classwork, and I would be a disruption. Still am a disruption. But yes, again, teachers, my goodness. There are some phenomenal teachers out there. And the shame of it right now, in my personal opinion, is they're being taught to teach to a test instead of teaching. And if only they could teach. And I know some, and I know they want to teach, but they have to teach to a test because that's what the department tells them to do. and that's what the school statistics are.
I think part of that too feeds into all the disruption too. I mean, because they're not engaged. You know,
I
it's
agree with
like-
you. I agree. I completely agree.
Yeah.
You know, I've heard that.
Well, FCAT's going bye-bye, so we,
Yeah.
you know, I don't know why they just couldn't just end it abruptly. Just if it's going, go.
It would be nice if they could get rid of a lot of these stupid tests, standardized tests.
Mm-hmm.
I mean, you know, SATs are one thing, but
Right.
to try to measure the effectiveness of a school, you know, give unit tests that are the same everywhere.
Mm-hmm.
You're not letting the teacher teach to that class.
Well-
You're forcing them to teach to the lowest common denominator.
But they're not teaching the student either. They're protecting
Right.
the reputation of the school and the grade of the
Right,
school.
and they're told that if too many kids fail, their job's on the line.
Right.
And it's a
Yes.
vicious cycle.
Mm-hmm.
But let me now, before I go into a little bit of law maybe, let me switch to the second part of National Speech and Debate Day. That was sort of my personal testimony, what it did to me. There's another video I posted today on my site and elsewhere. Not Red Bank Mother, Eatontown. Anyway, she's telling me where it was, and she's wrong. Now she's going to tell me she's not wrong.
Oh, she's your mother.
Right, I know that. Let me tell you about my experience so far this year being a co-coach at Lincoln Park Academy for the new inaugural year of speech and debate. I've learned things that I never thought I would learn. I thought I was going to teach these kids. They've done a little bit of teaching of me too. I've also learned what it really means to be a teacher. Again, I didn't think of a coach as being a teacher, but I've learned very quickly that I was wrong.
Mm-hmm.
I've learned the pride you have when you see a child progress and improve. It's an amazing thing. I understand why some teachers, the good teachers, why they love teaching, because it's a powerful drug. Just to see that improvement, see the self-confidence, the self-image change. And, you know, on my little team right now, it's an inaugural year. We don't have a big team. It's, you know, less than 10 regulars. And that's great. Glad it was that size.
Sure.
More might have been unmanageable. But each of them I could tell a story about if I had time, because I've seen different changes in each of them. And I've talked a little bit about it on some of the radio shows, you know, and I realized when I saw it was National Speech and Debate Day, and, you know, one of the things on the site is they're talking about, you know, video testimonials, and they have a lot of them, including Senator Elizabeth Warren, who co-sponsored the legislation for National Speech and Debate Day. And I realized, well, gee, I have a radio show.
Mm-hmm.
What better way, you know, than to tell people the value of speech and debate. And actually, Lincoln Park Academy may now have an elective return next year, speech and debate.
That's great.
So you don't actually have to be a part of the team if you don't want to. You can take it as, you know, an arts elective and get a credit, you know, towards graduation, and just learn some of the basics. But, you know, I've watched one kid vomit before the first tournament and end up, you know, bombing the first round completely.
Yeah, well,
Very
you
understandable.
start out very good, yeah.
But the second, third, and fourth rounds of her very first tournament, second place, first place in the round. Oh, my
And no
goodness.
more upset stomach?
No.
Okay, that's good.
And to see her, when we get the ballots back, and in the van, I read the ballots to the kids. And I make my own comments, obviously. It's coaching. To see that she plays second, and first, oh, my goodness. And to read the comments to her, and to see in the rearview mirror the smile, the reaction, to see her the next week at practices and carrying herself a little bit differently.
Sure, more confidence.
Oh,
yeah.
my goodness. That's a wonderful thing to see. We have one young lady, you know, who, like most people in America, not just women, is a little bit chunky. Okay, that's the way we all are in this country. most of us.
Mm-hmm.
And she does a piece on beauty. And it's a piece of poetry. And the piece starts out about how young girls in particular are taught to chase the definition of beauty. Become this, become that. Do this, do that.
Mm-hmm.
Eat this, eat that.
No, don't eat nothing.
Right, exactly. That's part of the poem, yes. Make sure you get the thigh gap, okay? And the poetry goes through the process of chasing that definition of beauty, believing that you have to achieve that to be beautiful. And as she's struggling with it, she's closed up her body. I know you can't see this on the radio. And she scrunches down, and her face contorts, and she's as small as she can possibly be, because that's the way you feel. And as she begins to realize herself, every time she gets close, the goalposts change. And that there's no need to chase it, because the ugly duckling wasn't an ugly duckling all along, it was a swan. And that no matter what you look like, you're beautiful, and if you can accept yourself for who you are, your self-image increases, your self-confidence. And to watch how she then, with her body and her face and her gestures, how she grows and how her voice changes. And she stomps her foot at one point, very effectively for the point in the poetry that it is. And she says, I'm me. I like me. I can't imagine in her delivering that in so far maybe 4 tournaments. That's 12 or 16 rounds. Did she impact any other young ladies that were listening?
No.
No, I don't believe that. I don't believe that for a moment. I believe that
Girls.
you listen to this stuff.
They're girls.
I think it still has an impact, particularly at least within people who do speech and debate and are working hard on their craft. I think it matters. I mean, my son does poetry and prose on depression. If there's a kid in there that's been depressed, I would like to hope that maybe what he has read may impact them a little bit, give them a little bit of hope, maybe some ideas as to things they might be able to try or places they can go. We've had kids on this LPA team choose pieces that spoke to them, which is funny, is what I suggested they do in the very first meeting, and they listened, which is wonderful. We have one young lady who does a piece on, police shooting young black males, and obviously it speaks to her, and you could tell by the way she performs it. This is giving them the opportunity to speak about something that's important to them, whatever it is. And that means that when something else happens, whether it's at school or among their friends or in life later on, they may have the self-confidence to speak out. Very briefly, I know I could speak all hour on this stuff. After we just recently had the first anniversary, God forbid, of the Stoneman Douglas shooting, and the kids that got together and went up to Tallahassee and demanded that legislators meet with them, and some of those kids were on the speech and debate team at that school. And without that experience,
Those would be the students you'd want to do the talking, right?
Well, yes, and maybe some of the others may be good and they don't realize it.
Yeah.
But without that, I know because I saw on TV that, boy, that speech and debate coach was really proud. I mean, all of a sudden these kids were thrust into an opportunity to really engage in social justice action, not just in a tournament, but in real life. And some of the skills they were taught came into action. And they used it, they seized upon it, and they fought, and they still are fighting. It's been a privilege and a pleasure coaching these kids, watching them, seeing them gain an understanding of really what this activity really is all about. And that's sort of, hey, that's my little testimony for National Speech and Debate Day. We've encouraged them to give their own, to write them up and maybe have them videotaped, maybe have them played a little bit during the morning announcements, and also help bring other kids into the team. Next year we may expand with permission and allow the middle school to join. We didn't want to do that this year because we didn't want to be overrun. We didn't want to have more than we can handle.
Yeah, you needed to see what you were getting
Right.
into. Yeah.
But maybe we'll expand it because the middle school kids, they can compete for 3 years as a novice. Then they can compete their freshman year in high school as a novice. And so you're competing as a freshman in high school as a novice, but you have 3 years under your belt.
Right.
Boy, at that point, you should be one of the best. And that's exactly what happens at the tournaments. You see the ones that win. They're at schools, Palm Beach County, Broward County, where they have all this stuff starting in middle school and sometimes even in elementary school. So I can't speak enough about this particular skill. It's not just public speaking. It's not just debating. It's what it does for you, what it teaches you, what carries with you for the rest of your life. And there's no better day to talk about it than on National Speech and Debate Day. So that's my long soliloquy.
That's your debate.
I'm glad we got 2 calls within that time. And we still have a little bit of time left to talk about law. I don't know if that'd be more interesting or less interesting. Okay. So the last couple of weeks, in between these segues and diversions, we've talked a little bit about different types of calls that seem to routinely come into my office, on similar types of stories on a repetitive basis. And some of them, these people have claims, and some of them they really don't. So let's turn to non-compete agreements that could really crush you folks.
And that's a really misunderstood term,
It is.
non-compete
It's
agreement.
Another name is a restrictive covenant.
That's not as nice.
Yeah, but what it means is you
Sounds-
lose your job and
yeah.
you may not be able to go to work where you want to work.
Yeah.
And these non-compete agreements are sometimes offered to you at the beginning of your employment.
Is it a one-sided agreement, or can it sometimes work for everyone?
It's a one-sided agreement.
Okay.
I mean, if you're at a higher level of employment, you can negotiate these things. They can be fairer. But for most people, it's a one-sided. It's here's your employment document, sign.
So if you want to work here,
Yes.
Okay.
A lot of them are, part of the initial employment documents. If you don't sign it, you don't get the job. But that doesn't mean you shouldn't read it, because how many people call us up and say, well, I got fired, or I quit because I was being sexually harassed, and I went to work at Dairy Queen and Carvel is threatening to sue me. I mean, they're a clerk. Well, who cares?
Right.
But I have a non-compete agreement. I can't do anything regarding ice cream or yogurt within 25 miles.
Take all those ice cream secrets to the competitor. Yeah.
And so they come in, I look at the non-compete, and very often, although there is some things that you can do around the edges, they're enforceable. They're highly enforceable in Florida, even if sometimes they make no sense.
But now what would have to happen is that former employer then would have to sue you, correct?
Well, they could send you a cease and desist letter, and then you could...
Can they also sue your new employer?
That's usually happens.
Okay.
And so very often, the cease and desist letter, I've sent a few myself, they go to the former employee and the new employer, and they threaten all sorts of things that can happen for violating a restrictive covenant and non-compete. And most of the time, that new employer does not want to get involved in that. That particular employee is just not worth the hassle.
No,
And
we don't
guess
even know
what?
you yet.
You're fired.
Yeah. Again.
At will employment, you're fired.
Yeah.
So these non-competes can really mess up a person's ability to work or provide a living for their family. A lot of times they're not offered at the beginning. They're offered somewhere in the middle. Somewhere in the middle of your employment, some lawyer has told your employer, you really should have non-compete agreements. Okay, Mr. Lawyer, draft one for me. And some lawyer, not me, not me sometimes, drafts a non-compete, and all of a sudden you're presented with the non-compete, and well, what happens if I don't sign it? You're fired.
Mm-hmm.
So you sign it or you don't sign it, but if you don't sign it, you're no longer working there. So a lot of people will just sign it, figuring, big deal, what's going to happen? Okay. The problem is, here's what the Florida statute says about non-compete agreements. Up to 2 years is generally enforceable. 0 to 1 year is presumed reasonable. 1 year to 2 years, there is no presumption either way, so they're usually enforceable. Above 2 years is presumed unreasonable, unless the employer can really convince the court that there's a reason you need to have more than 2 years. Geographic scope, which is the other key part of a non-compete.
Yeah. How far? How?
Well, I see a lot of different things, and I've seen lots of opinions in Florida, which are different than some other states. Let's say you're working for a big company, a Fortune 100 company, and they literally do work worldwide. So your non-compete says for 2 years, you cannot engage in whatever your job title is within the entire world. It's enforceable.
In other words, you may
within
not
the
work,
United
period.
States, within North America, within the United States and Canada, United States, Mexico, and Canada. I mean, I see these things. Are they enforceable? When they get to be that broad, you have to be at a much higher level, in terms of your position.
But you're a trained professional for that specific position usually, and that means you cannot work, period, because that's what you do.
And the Florida statute says that the court is not permitted to listen to sob stories about how it's going to affect you. Either the non-compete is legal or it's not legal. Mm-hmm. It does not matter how it's going to impact you. You start to try to give testimony about that to the judge is going to shut you down. It is not permitted. The statute makes that crystal clear.
Now, what they should do is they should allow it if you decide to move on from the company, then you need to wait out your non-compete. But if we can you should be able to go get a job.
Okay, some of them are drafted in that way.
Okay, well, that would be more protection to the employee.
It would be. And, if you are a higher level executive and you have a lawyer looking at the proposed non-compete, and this company really wants your services because they're technical in nature and you're valued, there's an opportunity to negotiate the non-compete. And for the lawyer to say, I'd like to take this out, I'd like to put this in, you do a little redlining, and you negotiate. And you get the best deal you can get, just like on any contract. Mm-hmm. But for the average salesperson, the average clerk, the average real estate agent, whatever it is, usually they don't run to an attorney. Usually they just sign it. Mm-hmm. And therein lies the problem, because when something goes wrong, then the attorney gets called. And very often these non-competes are enforceable. Now, again, sticking with scope, if you're the average type of employee, the type of person that typically calls my office, I mean, I've gotten high-level executives, but not the average person.
Can you work as an independent contractor?
No, not if it says that you cannot be associated, employed. It usually says employee, independent contractor, shareholder, partner, blah, blah, blah. Lawyers know how to write clauses, and they're all in there. Mm-hmm. And if it's not all in there, it says, or otherwise.
Which puts it all in there.
That's the catch-all phrase. All right, so if you're talking about the average person, and let's say you have a non-compete that says within the state of Florida, it's probably not enforceable. Now, does that mean you get off scot-free? No. Non-compete agreements are a weird bird. Goes all the way back to good old jolly England in the common law. Most contracts, virtually every contract, court cannot rewrite it. A provision is either legal or it's not legal. It stands or it falls. If it falls and the entire contract is affected, the contract fails. Not so with non-competes. Judges can what's called blue line a non-compete. They can change the duration and they can change the geographic scope based upon the testimony and what appears to be reasonable. That is really something that is unknown, in general contract law. So if you have within the state of Florida and your company really works predominantly in, let's just say, the 19th Judicial Circuit, Martin County, St. Lucie County, Indian River County, Okeechobee County, can you be precluded within the 19th Judicial Circuit? Probably. There are a couple cases that I have found that I use whenever I can that say it is really only reasonable to preclude you from working within the city or county in which you're actually employed. So that would,
unless you're a broadcaster on a big wattage radio station and you can be heard in multiple counties.
well, then I don't know how you figure that one out. But, so that helps a person in that, okay, maybe you can't work in St. Lucie County where you've been working and you live, but just go a little bit south to Martin County and, it may not be too hard for you for 2 years.
Mm-hmm.
Okay? So that's what now us lawyers have to deal with is, can we see a way that it is legitimately going to be blue penciled? Can we then write a demand letter saying, or respond to a cease and desist letter saying, take us to court if you got to, if you want to spend that kind of money, but here's our proposal for what we really think it should say and what would be reasonable, and you try to negotiate it. But the message I really want to get across is the danger of non-compete agreements that are either separate agreements or buried, paragraph 27 of the employment contract. Okay? The danger is you go in there assuming it's never going to be an issue. And very often, whether you quit or you're fired, it isn't an issue. Because you're not going somewhere, you're not taking anything valuable that it makes it worthwhile for the employer to do anything.
Mm-hmm.
It's a piece of paper, and they could, but they don't. Sometimes, your departure was nasty, and they come after you if it's for the heck of it.
It happens, right? Yeah.
Sometimes they come after you because they really think you're taking confidential business information or names of customers. Sometimes the employer is concerned, perhaps rightfully or wrongfully. Then all of a sudden we get the call, I'm being threatened, I'm being sued. Well, I understand, but it would have been nice if you realized you signed a non-compete agreement in the beginning,
Mm-hmm.
and if maybe you took a day and had a lawyer look at it. Because now you may have a problem. That's with any contract. You signed a contract. You're presumed to know what you signed. So, folks, non-compete agreements, be careful. Read them. Understand the worst thing that can happen. Okay? If it's enforceable, if it's going to be enforced as written, can you live with it? If it says you can't do your job within 50 miles, do you have family 100 miles from here and you're happy to move? Okay. But if this is where your roots are and this is where you want to stay, and now you can't do your type of work for 2 years?
And you got a mortgage payment?
Exactly.
Kids to feed?
Now you have a serious problem. Sometimes we could resolve it. Sometimes we can't. Sometimes they're just properly written. They're legitimate geographic scope. They're proper time duration. And there's nothing we can do for you. And then you're in a world of hurt.
Mm-hmm.
So it is something to be very careful of. And I got to admit, 90% of the work I do on restricted covenants are for employees. But, on occasion, I have an employer that becomes my client, and I'm asked to draft or revise what they have. They show me what they have. That's a horrible non-compete agreement. You're never going to get what you want with that non-compete agreement. Let me give you a much tighter non-compete agreement that your employees will hate, but I'll draw it in a way that I think will be enforceable. And the employees that sign that, they're going to have to live up to it.
Mm-hmm.
if it's enforced. And sometimes the way to get out of it, folks, you're not going to like this, you can buy your way out of it. Some employers will say, okay, give me X amount of money and I'll let you out of your non-compete.
Really?
Yeah. It's all negotiable.
Well, how about you keep that severance package that you weren't going to give me anyway?
Whole nother can of worms. Sometimes you see the non-compete in the severance package. You're not going to get all this money unless you sign this. Oh, please, folks, don't sign that one in a severance package on your way out.
Yeah.
Without having a lawyer look at it. My goodness.
Yeah, because if you didn't have an agreement,
don't be seduced by that money, and the agreement has a non-compete in it. Because unless you can live with that, unless you're planning on moving to Illinois tomorrow, and you don't care about that non-compete, have a lawyer look at it.
People have thought of everything, haven't they? I mean, really?
No. And that's why there are lawyers. That's why there are loopholes. People haven't thought of everything. You never can think of everything. But better lawyers are more creative than others. There are ways out of things. There are also ways to prevent people from getting out of things or make it harder. There are some pretty good contracts and non-competes and franchise agreements and all sorts of stuff.
I mean, I wouldn't say that the company isn't due their protection. I believe that they are. But to ruin someone's life for 2 years after they're gone is crazy.
Confidentiality is an absolute right of any employer. They have a right. Not only, you don't even need it in an agreement. It's protected by statute and common law. If you start giving away employees' proprietary business information, trade secrets, you're going to get sued and you're going to win, even if you never signed anything. Also, non-solicitation of employees, other employees. You're going to start your own hair salon, and you want some people to come with you. Well, if there's a non-compete that has a non-solicitation clause, you can't do it. And that's legitimate. If there's not, you can. Solicitation of customers. If you know of the customers just by nature of your work, or if you can know of them by nature of the industry, you're allowed to compete. But if the only way you could possibly learn of these people is through the trade secrets that you learned while you're working there, you probably can't do it. Otherwise, it's unfair competition. So there are lots of pitfalls, and you got to be careful, is the moral of the story. And, next week we'll talk about being a whistleblower and, I had homeowner, condo, and mobile home issues. That would have dovetailed very nice into the first call. I should have done that first. Anyway, folks, we are down to a minute. A lawyer can speak for a minute without a problem.
Okay, let's hear it.
7 years ago, when in the course of human events. That's not what I can do for my conscience. Okay. Have a great weekend. Enjoy yourselves. Hopefully it's warm. Maybe we can do some swimming. Next Friday we'll be back with Ask a Lawyer. Coming up is Ask a Rabbi. And this lawyer might be here too, in case the rabbi needs counsel. So if you need to, call my office. I didn't mention Cheryl's name. She'll kill me. Give Cheryl a call at 781-8003, and we'll try to help you. Have a wonderful week. Take care. Bye-bye.